equality before law. Under equality before law, Article 14 to 18, and Article 14 states that the state shall not deny to any person. There is no denial to any person. We say that equality before law and equal protection of the law. As we all know that equality before law is a British concept. This concept means that there is absence of privileges. There is no privilege over here. Under the equality of before law, there is no privileges. This is a British concept and it is a negative concept where there is absence of privilege. There is no privilege over here, and any persons or the session for there is no privilege for any person or a session and sections. All the persons are subjected to the ordinary law of the land. Everyone have the same ordinary law of the land and they are administered by the ordinary courts. No person is above the law. Now, when we look into the equality before law, we are looking that we know that it is a British concept and it is a negative concept. But the main important keyword over here is the absence of the privileges. There is no privilege over here. But when we are going for the equal protection of the law, we know that this is an American concept and it is a positive concept, right? American concept and positive concept. So, equal treatment under equal circumstances. This is the most important word. We are treating equally under same circumstances, whereas there is no discrimination while applying laws to the people situated similar conditions, right? So two words are important here: equal treatment under similar conditions, equally treating and similar conditions. Whereas equality before law, the keyword is privilege is absent. Equal protection of the law, we be having the equal treatment. There is equal treatment and similar for similar persons. Under Article 14, the class legislation is prohibited, but reasonable classification can be done if it is not arbitrary, artificial, or evasive. It should be based on intelligible, differential, and substantial. The reasonable classification should be intelligible, differential, and substantive distinction. Again, these two are going to be the keyword: intelligible, differential, and substantive distinction. Now, what is the rule of law? Now, equality before law, it is based on the concept of rule of law by A.V. Dicey, right? The rule of law is three. Out of these three concepts under the rule of law, in India, we follow the two principles: no arbitrary power. In the sense, nobody is punished except for the breach of law. Equality before the law, right? Under the rule of law only, we will be having the equality before the law. The rule of law is a concept which is given by A.V. Dicey. Now, equality before the law, all the citizens to be equal subjects of all the laws administered by ordinary courts. Now, primacy of rights of the individuals. We say that the constitution, because of the individuals, we have the constitution in the Britain. Individuals are responsible for the constitution. Because individuals have the rights and those rights are clubbed together, it becomes a constitution. Therefore, it is not a source. The primary rights of the individuals is what we have, the constitution. The constitution is not the source of the rights. The individuals are the source of the right according to the British concept. But here in India, that is why Britain are having unwritten constitution, because individuals are the source of right in Britain. Whereas in India, the constitution is the source of the right. So the third principle does not apply in India. There are few exceptions. We know these exceptions for the president and the governors enjoy the certain immunities like Article 361A. So the immunities for the president and the governors is mentioned under Article 361A. This Article 361A is very important and the number is also very important to be noted down. Article 361A. A freedom from the both the civil and criminal proceedings for publication in newspaper, t- TV, radio, a substantially true report of proceedings of the Rajya Sabha or the Lok Sabha, and state legislative assemblies or the councils. Right. No criminal proceedings under the president or the governor, and they cannot be imprisoned or arrested from any court during their office term. Right. Article 105 is the proceedings against the MPs when they are what they say against what they say or how they vote in a parliament. Article 194 is related to no proceedings against the MLAs for how they say and how they vote. So 105 is a privilege for the parliamentarians plus 89. We will be having the 194 is a privilege for the MLAs. Now here we say that no proceedings against the MPs for whatever they say in the parliament. No proceedings against MLAs for whatever they say against the so Article 105, Article 194, 361 is related to the immunities which is provided for the President, Governor, MP, MLA. Now Article 31C. When there is a law made to give effect to the DPSPs under the following articles cannot be challenged in the court for violative of Article 14 and even Article 19. Those two DPSPs are Article 39C. Now, what happens in Article 39C when there is a common resource? This resource must benefit the community, right? When there is a common resource, this resource must benefit the community. So for the common resource, for example, there is a pond. This resource must benefit the entire community. Therefore, it must be distributed, right? Equitable distribution of material resources of the community for common good. Now, what is 39C? Prevention of concentration of the wealth and means of production. Wealth must not be concentrated to one person alone. So, prevention of concentration of the wealth and means of production. Foreign rulers, ambassadors, diplomats have immunity from criminal and civil proceedings. According to UNO and its agencies, are also having diplomatic immunity. Article 14 is being completed. Now we are going for Article 15. Prohibition against of discrimination. This is only for the citizens alone. The state shall not discriminate any persons on the ground of race, religion, caste, sex, and place of birth. The state is not discriminating any person, first of all, and no citizen shall be subjected to any disability, liability, restriction, condition on the ground only of these are the grounds, right? Race, religion, caste, sex, place of birth. And with regard to, they should have access to shops, public restaurants. It's not restaurants, it's restaurants. They should have access to shops, public restaurants, hotels, places of public entertainments. The use of wells. So we say that there is a use of the wells, tanks, tanks. It is not talks, it is tanks. Bathing ghats, roads placed of public resort dedicated to the use of the general public and maintained wholly or partially by the state. Thus, under the second provision, the discrimination both by the state and the private individuals is prohibited. The first provision states that the state should not discriminate anybody with respect to race, religion, caste, sex, and place of birth in terms of discrimination, and the second is in terms of the access, right? This is fully in terms of the access to public places, which is applicable to both the state and then we have the private individuals. Exceptions to non-discriminations. What are certain exceptions? This will come, these exceptions, this entire exceptions are going to come under Article 15, right? Now, first is 15.1 and 15.2. Go like that. 15.3, 15.4, right? You have certain exceptions. The first one is going to be special provisions for women and children. We have special provisions for the women and children. So, in case of providing any provision for the women and children, discrimination can be done. Next is going to be special provision for the advancement of the socially and educationally backward class of the citizens for SCs and STs regarding their admission to the educational institutions, aided or unaided by the state, except the minority educational institutions. Now, for the second is going to be the socially and educationally backward classes of SC, ST. Right. Accordingly, we have given the central education institutions enacted a central in the educational institutions. With respect to jobs, we have Article 16 is related to the jobs, whereas Article 15 is related to the reservation in educational institutions. Here, creamy layer is going to applicable. Right. The first one is going to be you are making special provisions for the advancement of socially and educationally backward classes is what we have OBCs. Socially and educationally backward classes SC, ST, and in 2008 the Supreme Court given the direction that the central government to exclude the creamy layer of OBCs while implementing the law. Special provision for the advancement of economically even more critical situation is economically weaker socially and educationally. We have seen socially and educationally SC, ST. Then we are going for the economically weaker sections are added by the 103rd Constitutional Amendment Act. Special provision for the advancement of economically weaker section of the society are having admission in with respect to the private as well. This is added even by the 103rd Constitutional Amendment Act. Aided or unaided, other than the minority educational institutions. Now we have equality of opportunity in public employment. Equality of opportunity for all the citizens in matter of the public employment or for appointment to all the to any office under the state. Citizens cannot be discriminated on the grounds only of religion, race, caste, sex, place of birth. Now descent and residence is being added over here, right? So two categories which are added over here is descent and residence. Now we also have the exceptions. This is with related to jobs, right? Now first exception must be for descent and residence. Now, Parliament can prescribe the residence as a condition for some of the employments or appointments. Provisions only for the Andhra Pradesh and reservation in favor of the BCs alone. Reservation and promotion requirement the incompetent of the office related to religious or denominational institutions or a member of its governing body should be of the relevant religion. Now, here we are having discrimination against religion with respect to state or with respect to not even state or with respect to offices related to the religious institutions. This does not apply to the religious institutions, right? Because there are certain religious institutions which are controlled by the state as well. So this does not apply to the religious institution. First, for the descent and then the residence. We have first the descent and the residence. We have Andhra Pradesh. Descent and residence conditions are applied for some employment. This is for reservation in favor of the backward classes, plus reservation is also in the promotion. Favor of BCs plus reservation for promotions. Requirement that the incompetent of the office related to the religious and denominational institution or a member of its governing body should be of the relevant religion. Article 16 states that the state shall make special provisions for the reservation of the appointment of the post in favor of the economically weaker sections of the citizens. The existing reservation subject to 10% of the post in each category. Economically weaker section is 103rd Constitutional Amendment Act. The 10% of the reservation under the above clause shall not apply to SC, ST, and then we have the OBCs. It is for economically weaker section of the people. Recently, we say that the Supreme Court has upheld the 103rd Constitutional Amendment Act, which is for the
economically weaker criteria, which is only based on economic criteria, does not violate the basic structure of the constitution. Now we go for with respect to reservations in the jobs. Opportunity means a job. For 1979, Mandal Commission is the second backward commission. The first backward commission was in 1966. Now, here in 1979, Moraji Desai government has appointed a second backward classes commission under the BP Mandal, and it is also having an Article 340, right?
Article 340 is related to the Mandal backward classes. Appointment of the backward class commission. Appointment of the backward class commission to investigate the conditions of socially and educationally backward classes and suggest the measures. So we have socially and educationally backward classes. They are not also ordinary backward classes, they are socially and educationally backward classes and suggest the measures for their advancement. In 1980, the Mandal Commission has given its report and its implementation was in 1990. Declare reservation 27% of the government jobs for the OBCs. In 1991, the Narasimha Rao government has introduced a creamy layer clause, a preference to the poorer sections among the OBCs and 10% reservation of the poorer sections of the high class. Here, this was implemented in 103rd Constitutional Amendment Act. Right, 1992 Indira Swani case where 10% reservation of this was rejected and upheld at 27% with the creamy layer clause. So the Mandal Commission was in 1979. Report came in 1980. It was implemented in 1990 by VP Singh government and 1991 Narasimha Rao government also provided 10% of the reservations for economically backward class of the people, but this was rejected in 1992 Indira Swani case, which upheld the 27% reservation for the OBCs. Now, in 1992, since it was rejected in 2003, we have the OBC reservations for the sorry, not in 2003. It was 103rd Constitutional Amendment Act, which provided for reservation for the economically backward classes. Also, the court mentioned in Indira Swani case that there was no reservation in the promotions. Any existing reservation in the promotions shall continue only for a 5 periods up to 1997. The total quota reservation should not exceed 50% quota. A permanent statutory body should be created on the complaint. So in 1992 itself, there was National Commission for the BC has been created. As per the Supreme Court's order to create a permanent statutory body should be created to examine the complaints of over and under inclusion in the OBC list. What are the government actions is Nam Nandan Committee is to identify the creamy layer. The criteria for identifying the creamy layer is by the Ram Nandan Committee is for the creamy layer. The criteria for creamy layer is Ram Nandan Committee. National Commission for the Backward Classes came in 1993 itself by the Act and it became a constitutional in 102nd Constitutional Amendment Act Article 338B. We have 102nd Constitutional Amendment Act under Article 338B for the National Commission for the BCs, which become a constitutional body only in the 102nd Constitutional Amendment Act. That too, we have Article 338B for National Commission for Backward Classes becoming a constitutional body. 77th Constitutional Amendment Act of 1997, a new provision in the Article 16 to empower the states to provide reservations in favor of the SCs and STs that are not adequately represented in the state services. 85th Constitutional Amendment Act provides consequential seniority in case of promotion by virtue of the rule of reservation for the government servants belonging to SCs and the STs. We are going for consequential seniority. 76th Constitutional Amendment of 1994 Tamil Nadu government has a reservation act of 69%. Now the 50% ceiling was also ended by 81st Constitutional Amendment Act in case of the backlog vacancies. Even that 50% of the reservations is being exceeded. Right. Justice Rogini Commission under Article 340. So for the OBCs, we are having Article 340. Now here extremely backward classes, so even most backward classes and backward classes comparatively more forward. Now Article 17. Article 17 declares that untouchability, abolition of untouchability and enforcement of any disability arising out of this. Untouchability is a punishable offence under the law. Under the article, Government Enforced Untouchability Offences Act 1955, it is renamed as Protection of the Civil Rights Act of 1955. Right? The Untouchability Offences Act has been renamed as the Protection of the Civil Rights Act of 1955. It defines a civil right as a right accruing to a person by reason of abolition of untouchability. The term untouchability is neither defined in the Constitution nor by any act. It does not cover social boycott of few individuals or exclusion from the religious services. So here it does not cover social boycott of few individuals. Boycotting few individuals or it does not cover the exclusion from the religious services. It is one of the absolute rights with no exceptions. Right. Untouchability must not be followed, therefore, it is an absolute right. High Court. Untouchability under Article 17 does not mean untouchability. Literally, the practice of untouchability as it developed historically in the country. And the social disabilities imposed. Untouchability means you should not go for the dictionary definition. It means that the practice of the untouchability as it developed historically in the country. The practice which has been developed historically in the country. The social disabilities imposed on the persons due to their birth in certain caste does not cover social boycott of few individuals from their exclusion from religious services. So now we say that Article 17 is also applicable against the private individuals as well. Abolition of the titles prohibits the states from conferring the titles on any person. So the state should not confer the title on any person except the military academic titles. Prohibits the Indian citizens from accepting the titles from any foreign state. Now, a foreigner holding an office of profit or a trust under the Indian state cannot accept the titles from the foreign governments without the consent of the president. In order, even if a foreigner, if he is working under the government of India, he cannot receive the titles until he receive a order from the president. Right? No person or a foreigner having office of profit under the state can accept any present. You cannot accept the present, emolument, or office from the foreign state without the consent of the president. In 1945, national awards were instituted Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri. It was continued during 1977 and revisited in 1980. In 1996, Supreme Court upheld their constitutional validity. National awards should not be used as suffix or prefixes.